Hi, welcome back. We are finishing today going through the court documents filed by Prime Minister Andrew Holness in his application for leave to apply for judicial review against the Integrity Commission. Thank you so much for being here. I'm Dionne. Stay tuned. Okay, so we're at the point now in the documents where the Prime Minister is specifying the various types of breaches that he's saying has occurred. So let's start with breach of natural justice and procedural fairness. He says the investigation was procedurally unfair from the outset because the Commission failed to give him the sum or wealth that they were alleging was disproportionate to his lawful earnings and reserved to themselves the right to ask any questions and questions that were not relevant to the explanation that he was required to give under the Corruption Prevention Act. That's the explanation in relation to the earnings. He says procedural fairness required that the Director of Investigation and the Commission give him and the three companies adequate notice of their proposed decisions at every step of the investigation, or at best, before making recommendations that were adverse to their interests. He said the investigation process was wholly unfair in that the Director of Investigation and the Integrity Commission failed to give him and the companies notice of their adverse findings or decisions and to give them an opportunity to respond. He says they failed to give effect to his right to counsel and or to give consideration or proper consideration to the objections that his lawyers were making on his behalf. As a result, he said the directors abused their powers and or discretion by treating his legal objections as his refusal to provide information. So he's saying he was objecting to some of the questions that were being asked, and their response was to say he was refusing to give information. He said the Director of Investigation and the Integrity Commission failed to observe his right to counsel, and that prejudiced, and counsel here means lawyer, and that prejudiced his rights and interests when the Commission mischaracterized his objections and communicated that to the public by sending the report to be tabled in Parliament. He said the investigation was unfair from the outset because the Commission represented that they were proceeding under Section 14.5 of the Corruption Prevention Act. That's a section that deals with illicit enrichment. But he says they then went on to inquire into the business and the affairs of the three companies without reference to the procedure for investigating an offence under that section or telling Mr. Holness exactly what he was required to explain or what the new matter was that they said they had discovered. He says the Integrity Commission Act provides that the same person shall not perform the functions of investigation and prosecution. He said this was intended to cure a flaw that existed under the prior regime. Nevertheless, Section 14.5 was also amended to give effect to this objective, such that there is an impermissible commingling of the functions of the investigator and the role of the prosecutor in the investigation and prosecution of cases thereunder, compounded by the Director of Investigation's act of usurping the functions of the judge to be carried out at the trial of an offence of illicit enrichment. Okay, honestly, this sentence is very hard to understand because it speaks about the act preventing the person from acting as investigator and prosecutor, but they seem to be talking about the Director of Investigation acting as investigator and judge. Anyway, let's go on. It might become clearer. They said in this matter, the Director of Investigation acted as investigator, conducted hearings and made findings of law and fact in relation to the said facts concerning the offence of illicit enrichment, potential or indirect conflict of interest, the alleged unexplained sum of 1.9 million, and lifting the corporate veil. They say he proceeded unfairly by broadening the scope of the investigation such that there was a moving target, such that he demanded to investigate 2022 and 2023 declarations, and the investigation turned out to be a fishing expedition. He said the directors and the commission failed to follow the statutory procedure for examining and or investigating and or certifying Mr. Holness's declarations and failed to consider relevant matters and took into account irrelevant matters. He says they made adverse findings against him and the companies without giving them an opportunity to respond. He says there's a reference to the forensic examiner's work in the report. And he says the applicants, he and the companies, were entitled to see and respond to any adverse findings and benefit from any advantageous findings in it, but they didn't get a copy. Then he goes on to constitutional breaches. He says Section 14(5) of the Corruption Prevention Act breaches the presumption of innocence because it imposes an obligation on Mr. Holness to explain his wealth or be found liable for prosecution for inadequate explanation or failing to explain. All right, so this has to do with the fact that in an investigation for illicit enrichment, then you, if you're being investigated, you have to give an explanation as to how you came by those assets, or you could be liable for prosecution for illicit enrichment. So in other words, it puts a burden on you to explain, and that's what's called a reverse burden. Instead of the prosecution alone having to prove everything, you, the person who is being investigated, you, the suspect, have to prove that your assets were lawfully acquired. And that's what he's taking issue with there. He says it breaches the presumption of innocence. He's also saying that illicit enrichment section is unconstitutional because it breached Mr. Holness's right to due process, because it allows the Integrity Commission to authorize the Director of Investigation to investigate analyzed facts against the principles of law and impose that legal burden that I was talking about on Mr. Holness to disprove his guilt or a presumption against his interest. He says the directors and the commission infringed his and the company's right to fair procedures or natural justice because of what he calls the impermissible intermingling of or the lack of fairness, impartiality, and independence in the execution of the functions of the Director of Information and Complaints, the Director of Investigation, and the Commission. He said by disclosing the contents of the investigation and referring the report to the Financial Investigation Division, they breached his reasonable expectation of privacy. He says they acted in breach of natural justice because they were entitled to a hearing before recommendations were made that were adverse to their rights or interests. He said the disclosure that the companies are subject to investigation and have been reported to the Financial Investigation Division for further investigation is breaching their right to privacy. Okay, so he's saying their constitutional rights were also breached because their private information was disclosed, and that therefore subjected them to public odium, public hatred and criticism, including the fact that the companies now are being subject to investigation by Financial Investigation Division and or tax admin and any other competent authority. He said their rights to equality have been breached and their rights to equitable and humane treatment by a public authority have been breached. Then he moves on to irrationality and unreasonableness. He says the Director of Investigation and Integrity Commission failed to act on evidence, failed to take into account relevant considerations, or took into account irrelevant conditions, including failing to have regard to the true meaning and effect of the word disproportionate in the Corruption Prevention Act. He says the process that the Director of Investigation used in conducting his investigation and coming to his findings was unreasonable, unfair, and irrational. He said the decision, findings, and conclusions related to the combined net worth of him and Imperium of $1.9 million is unreasonable and irrational because they didn't have regard to the conclusions that Mr. Holness's net worth for 2021 and 2022 was negative, and there was no unexplained growth in his net worth for those periods. So he says the findings and decisions in the report are unreasonable and irrational, as no body or official mindful of their respective functions would have arrived at them. And he also says that the Director of Investigations was at the end of the process when he asked for an income and expenditure statement. Legitimate expectations is another heading. Mr. Holness is saying he was entitled to believe that when the 2021 declaration was being investigated, that the Commission would act independently, impartially, fairly, and in the public interest. He said he had a legitimate expectation that the Director of Investigation would have observed the principles of natural justice and procedural fairness and considered relevant considerations in doing his investigation. He said he had a legitimate expectation he would be provided with a threshold sum, that is a wealth element. He says he was not given background in relation to the alleged irregularities that were being investigated, and he wasn't told the proportion or the sum by which his assets were disproportionate to his income so he could fairly and accurately respond to issues. Then now, we look at ultra vires, illegality and abuse of discretion or abuse of power. Mr. Holness says the directors and the Commission acted with an improper purpose in sending the report to Parliament with extraneous material which was not the subject of their investigation or their findings in relation to the 4 accounts which had been left off the statutory declaration. He says a referral to Parliament for tabling of the matters contained in the investigation report, except for the matters relating to the 4 bank accounts left off the statutory declaration. He said that breaches the Integrity Commission Act, as only matters referred to in Section 54(3) can be referred to Parliament for tabling after submission to the Director of Corruption Prosecution. He said the Director of Information and Complaints failed, neglected, and refused to perform his statutory duty to examine Mr. Holness's statutory declarations for 2022 and 2023, and also failed to perform his statutory duty to certify Mr. Holness's statutory declarations for 2021 and 2022. He says referring the report to the Financial Investigation Division and Tax Admin circumvents the statutory and lawful procedure which requires a reasonable suspicion of corruption and wrongdoing, and if there is such a suspicion, to refer the report and findings. Now this says to the Director of Corruption Prevention. I'm assuming they mean the Director of Corruption Prosecution. Further, in the absence of such a finding, the failure to certify the declaration, he says, is also an attempt to circumvent the procedure or the requirements of the law. He says the Director of Investigation acted ultra vires the Integrity Commission Act, meaning outside the bounds of the Act, and or illegally, having completed his report and not having found any corruption or wrongdoing by failing to recommend to the Integrity Commission that Mr. Holness be publicly exonerated. He said referring the report to Financial Investigation Division and Tax Admin is an unlawful delegation and or abdication of the Director of Investigation and the Integrity Commission's statutory responsibility and or the responsibility of Director of Corruption Prosecution. He says tabling the report was intended to embarrass and cause harm to him and the 3 companies, and as such, it was done in bad faith to prejudice and harm Mr. Holness, given that the entire scheme of the Integrity Commission Act is to ensure confidentiality and secure fairness to those who are being legitimately investigated. Then he speaks of the special report that came from the Integrity Commission. And he refers to the section that said there can be no finality until the Financial Investigation Division has completed its work, and that there can be no certification of a declaration until the Director of Information and Complaints is satisfied that the declaration has been duly completed. He says the statement, there can be no finality in the matter until the FID has completed its work is contrary to the statutory regime, as the responsibility to complete the work is put on the directors and the Integrity Commission and no other entity. So he says this statement is illegal and or ultra vires, outside their legal powers. He says the Integrity Commission statement that there can be no certification of the declaration until the director is satisfied that it's been completed is made based on an unlawful foundation, in that it presumes that the director's satisfaction is to be generated by the work of others, in this case the FID, and he's saying there's no statutory basis, no basis in law for that position. He said the Director of Investigation and the Integrity Commission have usurped or encroached on the role of the Director of Information and Complaints. He's the one who examines the declaration. And he said the Director of Information and Complaints has ceded or given up his statutory role to them insofar as he hasn't examined the 2022 and 2023 declarations and has said he's unable to provide any information on the matter. He says the Director of Investigation illegally assumed jurisdiction over the 2022 and 2023 declarations. This because the allegation of disproportionate assets to lawful income was limited to the 2021 declaration. He said the investigation was improper and ultra vires the Integrity Commission Act and the Corruption Prevention Act. He says the subject matter of the referral for investigation was a 2021 declaration, and the commission and directors expanded or were complicit in expanding the scope of the investigation from 2019 to 2023. He says the Director of Investigation told him, Mr. Holness, that the subject matter for investigation for the 2021 return was bank accounts and investment accounts that required explanation, business associations and investments, funding of liabilities associated with business activities. He said those matters are not the subject matter of an allegation of illicit enrichment, in that they don't deal with the threshold question of whether Mr. Holness owned assets disproportionate to his income, and in any event, no sum was provided to him for explanation. And he says so far, they haven't started to look at the 2022 and 2023 statutory declarations. He says the Director of Investigation and the Commission acted ultra vires the Integrity Commission Act illegally or in a procedurally unfair manner by lifting the corporate veil, having not found fraud or wrongdoing, or applying to the court to lift the corporate veil. He said this was in circumstances where the report found there was no unexplained growth in Mr. Holness's assets and liability relative to his income in 2021 and 2022. He says the Director of Investigation and the Commission have acted in bad faith, unlawfully and unfairly in recommending in the report and submitting it for Parliament, as at the time when the finding was made, the Director had already found that Mr. Holness's net worth for 2021 and 2022 did not meet the threshold of disproportionate assets to earnings. He says, in addition, the alleged net worth for 2022 was arrived at by improperly combining the assets of Mr. Holness and Imperium. He says the Director of Investigation and the Commission improperly failed to provide Mr. Holness with an opportunity to give an explanation in relation to the alleged disproportionate assets / net worth of 1.9 million. He says the Director of Investigation and Commission acted unfairly and illegally when they failed to give him the opportunity to explain, as required by the law, the alleged disproportionate sum. He says they failed to apply the correct test to an investigation for an offence under the illicit enrichment section, in that they treated any increase in net worth as disproportionate without regard for the word disproportionate or the true meaning of the word disproportionate, or making a proper assessment as what would be considered disproportionate. He says the Director of Investigation and the Commission acted illegally when they required him, Mr. Holness, to submit an income and expenditure statement. He said they acted in bad faith when they alleged that he refused to provide information when they knew or ought to have known that he had exercised his right to counsel, as required by law. He says accordingly, the findings, conclusions and or recommendations in the investigation report were made in breach of the principles of natural justice and procedural fairness. He says the process utilized by the Director of Investigation was unfair, unreasonable and irrational. And he says the failure of the directors and the commission to observe the principles of natural justice and procedural fairness in conducting the investigation and judicial hearings breached the principles of legitimate expectation. So there you have it. We've gone now through the investigation report. You can see my previous videos for that. We've also gone through Mr. Holness's response as detailed in the court documents he's filed in this application for leave to apply for judicial review. So a number of different issues want to think about in terms of what's going on, what are the questions that have been raised and so on. I'll continue, of course, to provide coverage of this issue. Thank you so much for watching. I'm Dionne. See you next time.